Good evening, everyone. Welcome to the October 2024 labor law update. This month, we don't have much to go on with the rules and amendments. The Kerala Factory Rules 1957 have been amended, wherein a proviso has been inserted to Rule 8. So in the event of a factory being closed owing to a financial crisis or lack of material, and then somebody else comes in to reopen that factory, if there is a new promoter coming in, to minimize the financial burden on such transfer of licenses, they have said in the new provision that there will only be an amendment fee, and you can even use the earlier license itself going forward. The government of Goa has made certain changes to the rights of persons with disabilities. It has constituted a committee to look into it and what is to be done with the people who are the beneficiaries of the act. The Code of Social Security looks at providing certain benefits to gig and platform workers. The Ministry of Labour has now come out with a portal where aggregators are to be registered. Similarly, the gig and platform workers also should start to get registered under the eShram portal of the Government of India. This was issued even last year by the Delhi government. They have issued it once again this year as well. A notification pointing out that the principal employer should also look into the fact as to whether their contractors are paying bonus. And the notification also says that principal employers could be held liable if the contractors fail to pay the bonus. The question of notifying the internal complaints committee under the POSH Act, the Gurugram government has again there issued saying that many companies are found to be not forming committees, and therefore they said it's a very crucial committee to be formed. They want awareness on the POSH Act to be done, and so emphasizing the need for complaints with the POSH Act, a circular has been issued. The quiz question is, an establishment provides for gratuity as per its pension scheme. So under the pension scheme, there is a gratuity. Will employees covered in the pension scheme be entitled to gratuity under the Payment of Gratuity Act 1972? Please do post your questions in the chat, answers in the chat box. In the Across the Globe platform, we are looking at the Singapore government introducing a platform workers bill to not only provide social welfare, but other enactments like Provident Fund, what we have as an ID Act, something similar, Trade Union Act. So they've brought in a bill to cover all the platform workers like regular employees. So they are not going to be in any manner distinguished between a platform worker and a regular employee. This bill would now try to bring in your cab services and things within the purview of a regular employee. The New York state has brought in a law which provides for 20 hours of paid leave in the 52 gestation period during pregnancy. This can be used at any point of time by the concerned woman. This is one of the first laws that have come about in the US. It's like a bank. You bank in 52 hours. If you have a medical checkup to go, you could use it. Or if you don't feel well, you could use it. So there is no restriction on the manner in which it's to be used, but it's a 20 hours paid leave that pregnant woman would be entitled to avail before delivery during the pregnancy period. In Netherlands, we talk about 100 more employees. In India, we say of permission for closure and retrenchment. Here they're saying you need to report on the emissions with regard to work-related travel and commuting. The first case we are looking at in the case law segment this month is about an employee superannuating and the employer not paying his dues on time. The employee approaches the Labour Code under Section 33C(2) of the ID Act, seeking for interest. The Labour Court also grants the interest. The High Court, however, felt that in 33C(2), unless there is a pre-existing right to claim interest, the Labour Court could not have granted the interest and has held that interest cannot be granted in an application under Section 33C(2) in the absence of a pre-existing right. The next case pertains to a charter of demands where the employees had approached the Industrial Tribunal by way of an industrial dispute seeking for revision of wages. The tribunal partially granted certain reliefs. The High Court restricted the relief but still granted some more relief. But the Supreme Court found that a crucial question is the financial condition of the employer has not been appreciated by the tribunal in a proper manner, nor by the High Court. The Supreme Court therefore remanded the case back to the tribunal. So key question when it comes to increase in wages is the financial capacity of the employer. If that financial capacity issue is not decided in a proper manner by the tribunal, then such an award is bad in law. That's the legal proposition that you get from this judgment of the Honorable Supreme Court. In the Knowledge Corner this month, we are looking at continuity of service and attendant benefits. What do these terms mean? So normally when an employee's workman is dismissed, he goes to the Labour Code. The Labour Code could grant relief. It could mold the relief under Section 11 capital A of the ID Act. When molding, it could give relief in different forms. So it could be reinstatement with continuity of service and with back wages, without back wages, without continuity of service, without attendant benefit. So that could be different types of relief that the Labour Code could come out with. So what is this terms continuity of service and attendant benefits that is there defined under? And if a Labour Court were to grant it, what happens? Are they entitled to all these reliefs? Is the question that normally comes into. So what is this continuity of service and attendant benefits? So if the award directs only reinstatement with continuity of service, so what are the benefits that an employee gets? Is he entitled to promotions? Is he entitled to notional increments year on year? These are the questions that arise from this issue. The Supreme Court had the occasion to see in one case of Andhra Pradesh State Transport, where the High Court held against the employee. It's a case where it was reinstatement with continuity of service, but without back wages. So the question was, what do we mean by continuity of service? So the Supreme Court held that increments is not part of it. The period. So continuity of service would only mean that the period will be reckoned for retiral and terminal benefits like gratuity, etc. So that period would need to be reckoned. But the Delhi High Court, for whatever reason, took a slightly different view on this aspect. It also came to the conclusion that the continuity of service would mean the period should be reckoned for the benefits, for terminal benefits, but it also granted notional pay and increments. But this is the one-off case is what we would say, because the Andhra Pradesh High Court again has clarified this position to say, when you mean continuity of service, it is only that period will be reckoned for purposes like gratuity or pension, or it will be reckoned, but it is not that a notional increments will be granted. So no increments will come. So here, one more case where the Madras High Court dealt with, of course, is a government employee. He was again taken back, though his name was found placed in the promotion panels. he had not received any benefits and therefore he filed a writ petition. The Madras High Court also confirmed that it doesn't mean that he's entitled to all the benefits automatically unless the rules and regulations provide for it, because this is the case of a service law, so not from an award. So the sum and substance of all these judgments that we get to see is that if you're to the continuity of service would only mean seniority and pensionary terminal benefits alone will be entitled. So no other monetary benefit flows from this except for that period being reckoned for pensionary and terminal benefits and the seniority being protected. But when it comes to attendant benefits, if the courts were to grant attendant benefits, then it could lead to increments, it could lead to bonuses, it could lead to other monetary payments which he would otherwise been entitled had he attended service. So what is the award of the labor code? Is it only going to be reinstatement? If it doesn't even say continuity of service, then he won't be entitled to anything. But if it says continuity of service, then he will be entitled to seniority and reckoning the period for pensionary and terminal benefits. If it says attendant benefits, then the employee is deemed to be as though he's worked and he'll be getting all benefits for that period. So these are crucial two issues that you need to see whenever an award comes on, whether continuity of service and attendant benefits is provided for or not in the award. Moving to our next segment in Lex Posh, we have a very interesting case. Again, a case which is not in the run-in-the-mill case, very different one where the woman took a taxi to go to her workplace. It was an aggregator who was providing the service. So through a platform, an app, the woman booked the cab and the driver was watching pornographic video and he was making her extremely uncomfortable. She wanted to get off the car, but she couldn't do. And somehow, and then she started to make complaints to the aggregator, then to the police, and even to the IC. The IC of that aggregator came to the conclusion that the driver was not its employee, and therefore the question of the aggregator, the IC acting on it will not arise. The concerned women approached the Karnataka High Court. The Karnataka High Court held that the IC of the aggregator has the power and they should have taken up the complaint. Further, it has held the driver to be an employee, which is quite far-reaching, given that even the new courts don't look at gig workers as employees for purpose of any of the courts. But this is a very different development of law and march of law that we are seeing in this case. It has gone into the subscription agreement between the driver and the aggregator. The aggregator rules that is there, and ultimately is directed the IC to inquire into the complaint. Not only that, to avoid it, a compensation of 5 lakhs plus 50,000 towards cost. This is by a learned single judge of the High Court. We will need to wait and watch whether this judgment is going to be affirmed by the division bench of the Karnataka High Court or the Supreme Court, or what happens. We'll keep you posted on this regard. Going back to a quiz question. Under the Payment of Gratuity Act, there is a provision to seek exemption. So unless an exemption is sought for, even if you provide for gratuity in terms of the pension scheme, an employer is liable to pay gratuity in terms of the Act. So if the Act is applicable and if you don't get an exemption, even though you may be paying a different gratuity from the Act, the employee can still make a claim under the Act. The complaints calendar for the month, we would be sharing the PowerPoint with you, and you could certainly have a look at the complaints from there. Thanks for joining us and looking forward to meet you again on 7th November at 5 p.m. Thank you.